Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Laos Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Buying and Selling Home Health and Hospice Agencies. Our presenters for today are Jennifer Papapanagiotou and Heidi Kocher. Jennifer's practice focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing businesses arrangements for compliance with federal and state fraud and abuse laws and drafting a wide variety of legal agreements. Ms. Papanagiotou is knowledgeable in all aspects of state licensing for home health and hospice providers and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. As for Heidi Kocher, she has been a partner in the law firm of Laos Parker for over 20 years, and she has over 20 years of experience advising and defending healthcare clients on legal and regulatory matters affecting providers of all sizes. She is an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes serving as a Chief Compliance Officer and Chief Privacy Officer, implementing the various requirements and aspects of corporate integrity agreements, and responding to and defending audits from Medicare, Medicaid, and private insurers up through all to the LAJ level. She received her JD from Georgetown University Law Center. She is licensed in Texas, Maryland, and admitted to the U.S. Court of Federal Claims. She is certified in healthcare compliance. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box and we'll address as many as possible at the end of the presentation. And I will be sending out a copy of the PowerPoint slides tomorrow. So without further ado, I present to your speakers, Heidi Kocher and Jennifer Papanagiotou.
Thanks, Gio. This is Jennifer. Welcome, everybody. Thanks for spending your lunch hour with us. Gio, if you can get us to the next slide. All right, so this is just a brief outline of what we want to cover today. We're going to talk about some mergers and acquisition trends, sort of basics on transactions, health laws that apply to these kinds of deals, the important steps and documents that we generally see in virtually all transactions, post-closing issues to be aware of, and then some special considerations for home health and hospice. And let's go to the next slide. So current trends, what are we seeing these days? There have been a few interesting and somewhat significant regulatory things that have popped up over the last year, 18 months. Obviously, pandemic-related enforcement and audits are continuing and have become quite active, whether that's related to PPP loans, HHS, provider relief funds, SBA disaster loans, and we're also seeing quite a bit from the HRSA uninsured fund audits going on. So these are all issues that buyers are examining in transactions when they do due diligence. They want to make sure sellers have dotted their I's and crossed their T's and appropriately used and reported their use of funds. I'm sure people in the industry have seen the announcements about hospices in certain states where they undergo true chows or have 100% change in equity owners are going to be subject to enhanced oversight. Those of you in Louisiana are fortunate this does not apply to you. But if you happen to have agency investments in other states, or you look at acquisitions in other states, one of these four, for example, like if you were going to expand into Texas, this is an issue. And enhanced oversight generally means a period after closing where the Medicare contractor is going to most likely be doing some kind of pre-claim review to ensure that new ownership is competent, essentially. The big change that they implemented effective January 1 of 2024 was that CMS extended the 36-month rule to hospices. Now, this has been in place for home health for many years. And essentially this rule says that a home health or hospice that is certified by the Medicare program cannot have a change in majority ownership more often than every 36 months. I've had a number of proposed hospice deals come across my desk over the last 6 months or so, where sellers are trying to sell a hospice that is subject to this rule, and it really, it's new, not everybody's aware of it, and unfortunately it is affecting timeline for some deals. And sometimes there are exceptions under this rule that sometimes apply, not often, but sometimes, and there are sometimes ways to structure around it. But that being said, it's something to be aware of if you're looking at either home health or hospice target. You really have to vet whether the transaction is going to be impacted by this rule. Integrity auditors are obviously still very active. Everybody is back to business as normal after COVID. We're seeing suspensions and not as many revocations these days. I don't know if that's because they're turning their resources to other things, but we are seeing a ton of auditing, whether that's TPE audits or UPIC style audits. I'm seeing a lot of SMRC audits lately for whatever reason. So just, that's sort of business as usual. That's always been the case in home health and hospice. And we've seen changes in how deals are being priced. Used to be buyers looked a lot at patient census as their key metric for valuing a deal. Most buyers are they may look at census and they may look at the stability of census or the growth of census over time, but they're really looking at EBITDA. They want to know what's the revenue coming in, what are the sources of that revenue, and it's really replaced patient census as the key metric for how to price a deal. Let's go to the next slide. What should you know? What are sort of the basics about a transaction? And these are really big picture things, not specifics necessarily about any given deal, but where do you start? Well, first and foremost, acquisitions take time, and you have to be methodical in how you approach one of these. And that just by its very nature takes time. Buyers need time to complete thorough due diligence and to vet the target that they're looking at. And I can 100% guarantee you that if you try to accelerate the timeline and don't do thorough due diligence, it's sad to say, but 9 times out of 10, it's going to come around and you're going to pay for it later. So I highly encourage buyers, especially, and sellers to be realistic about how long it takes to complete a transaction from the very first time two parties discuss something until you actually close that transaction. And we're seeing lots of smaller companies that are maybe family owned and operated, or have just a couple of owners, or they're local businesses that don't necessarily cover a large geographic area. They are definitely looking to sell. The activity since COVID, it was really, really active in 2020 and 2021. There was kind of a lull when interest rates went up. But I will say in the last 12 months, things have definitely picked up. And that level of deal activity, I have a lot going on right now as far as transactions. It's busy. I don't think anybody, buyer or seller, should try to DIY a transaction. You need a lawyer. Both sides need attorneys, and not the same lawyer. You each need your own counsel. Healthcare is subject to so many laws and regulations, and there are some unique issues in healthcare, and it is so helpful for both buyer and seller to have counsel that not only understands transactions, but specifically understands the healthcare industry and has some specific knowledge about the healthcare industry. If you just go out and hire a general M&A guy who's never done a healthcare deal, trust me, they're not going to know what the 36-month rule is. And they're never going to think of it because it's not something they deal with every day. It is not uncommon for parties, whether buyer or seller, to hire accountant or valuation experts to review and advise on what their the target entity and what it's worth. We're seeing, depending on the size of the transaction, who the buyer's of, they're doing quality of earnings reviews, whether they do this in-house or they do those through some kind of outside vendor. Sometimes I have sellers call me up and they're like, I'm looking at selling my business and I've had these people contact me, or I've had 2 or 3 people contact me, but offers are all over the place and I just don't know what my business is worth. There are people out there that can help you navigate that, whether that's a broker or a financial analyst who works in the valuation industry. So I think those resources are really, really important for sellers to really better appreciate what the value is of their business. Let's go on, please, to the next slide. Buyers, this is for buyers. Do your homework and don't be afraid to walk away. You know, it's just the reality. There are lots of ways to customize or adjust a transaction based on risks that are identified during due diligence. You know, sometimes it's a matter of carving out a larger holdback escrow so that the buyer has a little more post-close protection for a period of time from things like audit risk. Sometimes it affects purchase price and you need to renegotiate your numbers based on what you find in due diligence. Sometimes the issues are so big, you know, buyer and seller just can't get on the same page about what they think the business is worth, given the risks the buyer thinks are present. You know, I just really encourage buyers, especially, you really have to be practical about these things. Not every target is a good target, and sellers, not every buyer is a good buyer. It's the same goes both ways. Many deals will get to the letter of intent stage where a buyer documents what they're willing to pay if certain facts are correct and if due diligence looks good. And lots of times you never get past that stage. It happens all the time. Every deal is different and is based on a unique scenario that each buyer and seller finds themselves in, but they generally have the same documents and processes. We say about 70 to 80% of transactional documents are pretty standard, whether it's an equity purchase or an asset purchase, and 20 to 30% are specialized to a particular industry, in our case, healthcare. And in healthcare, transactions are, like I said, a little more specialized, so they have some additional regulatory concerns you have to deal with. Let's go to the next slide, please. All right, so important steps and documents in pretty much every transaction. First and foremost, letters of intent. Letters of intent are certainly not mandatory, but it is, I would say, they're present in probably 90% of transactions that I work on. An LOI it's really useful. It's non-binding in most respects. We'll talk a little bit more about letters of intent, what portions of them are binding versus non-binding. But really what a letter of intent does is it sets the groundwork for the whole transaction. And it really is the first opportunity for buyer and seller to get on the same page about the deal. What are the big, broad terms, purchase price, timeline, and some of the big ticket issues in most transactions. So again, optional, but very, very common. Once you have a letter of intent, generally speaking, you launch into due diligence. There may have been some sort of lightweight diligence done before a letter of intent. Usually that's just looking at some limited financial information, maybe vetting some credentials. Due diligence, though, done properly, is a very intensive process, and the scope of diligence is going to depend sometimes on the type of transaction. Asset transactions will have a little bit different focus than equity transactions. And we'll talk about the difference in those later on, but basically in an asset transaction, you're buying the assets of the business and the owner will be a new legal entity. You get assignment of the Medicare and Medicaid provider agreements in that scenario, and generally speaking, the license, either through a child process or whatnot. But you're able to shed other assets of the business that you don't want. You can pick and choose. In an equity deal, you're buying shares or membership interests, depending on the kind of legal entity is, and you have different risks. You're going to own that company and all of its problems. And so the diligence in equity deals tends to be a lot more intensive. So after diligence, once everybody's satisfied, and usually towards the end of diligence, we draft and continue to further negotiate the purchase agreement. Purchase agreements are almost always drafted by the buyer and their counsel. They're going to talk about purchase price and terms, including any escrow or holdback, and any kind of post-closing payments that may be involved, like earnouts. They'll cover representations and warranties. These are generally sellers' representations and warranties. Those are the most important ones. And these are facts and things that are true about your organization. Big section will cover indemnification for liabilities. Generally, this is the seller indemnifying the buyer against liabilities that pertain to pre-closing time periods. This is things like audit risk. It could be employee liabilities. It could be any liability that could pertain to a pre-closing time period, but may come up after closing, is covered by these indemnification provisions. You'll also have exceptions and limitations to indemnifications. These are things like caps on liability. And then there will also be a discussion about ancillary closing documents. And then once your purchase agreement is fully negotiated and your diligence is fully completed, presumably you'll move to closing. Sometimes you're doing a simultaneous sign and close, and sometimes you're doing a signing with a delayed closing, which everybody, I tell people that's like buying a house, where you sign a purchase agreement or your offer at the beginning, and that's all the terms you've agreed to, and you've laid out a path to get to closing with certain conditions that have to be met. So that's what I call a sign with a delayed close. So let's go to the next slide. So we're just going to take a pause right now and kind of reflect on what we've covered. So before you sign a letter of intent or a purchase agreement, we strongly recommend that you engage an attorney experienced in healthcare and transactions to help you understand what you're signing. Make sure the agreements that you're signing reflect your expectations of the deal. Have the agreements properly documented the parties' agreement over this particular transaction. You have to consider federal and state laws that can impact the terms and timing of a healthcare transaction. Does your particular state, for example, require a license application to be filed before the transaction closes? In some deals, that's required. In other deals, it's not. Your personal attorney, whether it's the buyer's attorney or the seller's attorney, can outline sort of limitations and risks in how purchase price is structured, financing, notice periods, and other key terms in those documents, and help you understand them fully. And I'll just give you an example. If a buyer is going to pay a seller over time, the healthcare fraud and abuse laws can sometimes limit how long that period might be or how it is structured. So it's important that you have your own counsel in getting into these deals. I've looked at lots of deals where a buyer and a seller, business people got together and negotiated a deal. I did this recently, actually, it was last year. It was a hospice deal in another state. And the business deal they negotiated, bless their hearts, would not work under regulatory provisions. And we had to, go back and rethink how to achieve everybody's business goals and still get a satisfactory deal in place. But we had to vastly alter that particular post-closing payment structure that was being proposed. So, I tell them, well, if you'd come and talk to your counsel before you negotiated the deal, we might have saved you some time. I mean, it worked out, but it did add extra time to the process. Let's go to the next slide. So we'll talk a little bit about some of the relevant health laws. I don't want to bog us down too long, but I just want to make you aware of them. There are two primary laws we worry about, the Stark Law and the Anti-Kickback Statute. We'll touch on the Stark Law briefly. The Stark Law has a very limited impact, frankly. It prohibits a physician from referring patients for designated health services to an entity with which that physician or his immediate family has a financial relationship, unless an exception applies. Stark Law is a civil law. It's a strict liability statute. You must comply with an exception, or your arrangement violates the law. And the effect of that is that any claims that are filed for referrals in violation of this law have to be refunded. And you can also be assessed fines and penalties. So you have to comply with Stark or bad things happen. The good news is that it kind of requires a few baseline things that carve out a bunch of transactions. So first, it has to include a designated health service. Hospice is not a designated health service. Home health is. But if you then look at the law itself, prohibits a physician from referring patients for designated health services to an entity with which the physician has a financial relationship. It is really, really unusual, frankly, to see physicians have ownership interests in home health services if they are a potential referral source. There's such a very narrow Stark exception that allows that arrangement to exist. Essentially, the only way a physician can have an ownership interest in a home health agency that they refer to is if it's entirely in a rural area. There's like this tiny little carve out for that. Otherwise, you just don't see physician investors in home health unless they are never a referral source to that home health agency. For that reason, we think about Stark and we want to make sure it's not an issue in these transactions involving home health, but 99.999% of the time, it's not a problem. That being said, we can talk a little bit about what it would mean if it did. So let's go to the next slide. There is a Stark exception for what are called isolated transactions. So if we do find ourselves in a situation where it is going to apply, we have this exception available to try to fit the transaction within it. And we would have to fit it within this to make it work. I don't want to spend a lot of time on this other than to say that it's rare we have to worry about this. Let's go to the next slide. We do, however, have to worry about the anti-kickback statute. It prohibits the knowing and willful exchange of anything of value to induce or arrange for referrals payable by Medicare or Medicaid. It is a criminal statute, and the violations can carry very significant penalties and jail time. Why is this a problem? Well, transactions among parties who refer to each other are subject to the anti-kickback statute. So earnouts, post-closing payments, where a seller may stick around and continue to work for the buyer, or the seller is going to remain in the community as some kind of referral source to the agency, where there's some kind of post-closing payment, have to be really carefully structured. I've actually had this come up. It has been an issue in deals I've worked on before. And there are, a couple of ways to slice and dice how you address it. One of them is to eliminate the earnout provision entirely. The other is to make sure that an earnout is never related to referrals and is based on other, it's more complicated than that, I would say, because you can indirectly kind of link all that stuff together. But this is an issue that comes up in transactions. And it's one of the reasons why sellers and buyers really need their own counsel who knows something about healthcare to make sure whatever deal they've entered into is appropriate. So let's go to the next slide. So what do we do if we find ourselves with some kind of anti-kickback statute risk? Well, one, we try to eliminate that risk. We try to figure out a way to not have the particular transaction structure fall under that anti-kickback statute. Can we eliminate the earnout, or can we modify it somehow so that we're not going to be subject to this law? There is this safe harbor related to sales of practices. It was originally created to allow hospitals to buy physician practices. It's not customized or really designed to cover home health and hospice transactions. That being said, because the anti-kickback statute is a criminal statute and safe harbors are optional, not mandatory, we can use safe harbors in situations that they weren't necessarily 100% designed for, to give us sort of a good go-by for how to structure something that we believe will be low enough risk that it wouldn't cause the government to determine that the arrangement was illegal. The sale of practice safe harbor was there to protect transactions among practitioners and between practitioners and hospitals if every element of that safe harbor was met. It places time limits on completing a transaction and on referrals between buyer and seller after closing. Again, like I said, failure to comply does not make your transaction illegal, but it does mean the government would look at all the facts of the situation to determine if one purpose of the arrangement was to reward referrals, generally from the seller to the buyer. Let's go to the next slide. So if a deal doesn't fit in a safe harbor, as I said before, what can you do about that? Well, one, structure around it so that it's not an issue. Two, you really got to have a healthcare lawyer look at the deal and provide an advice letter analyzing risks and documenting what you're going to do to mitigate those risks. And sometimes it's a matter of beefing up your assessment of fair market value of the deal, depending on how your purchase price and all the related provisions have been structured. So sometimes retaining an appraiser can be helpful as well to beef up that your deal is commercially reasonable and is not intended as a way to reward referrals after closing. Let's go to the next slide. Okay, so important steps and documents. I'm going to cover the very first couple things, which letter of intent. We said earlier that this is an optional document, but it's often, it's very, very common. And the idea is to lay out key terms and sort of open the negotiations between buyer and seller. As I said before, they're generally non-binding except for confidentiality provisions and exclusivity provisions. Generally, buyers and sellers, buyers specifically, and sellers specifically, sellers want confidentiality, as do buyers. They don't want either side talking about these deals outside of the negotiation room. And exclusivity generally means that the buyer wants the seller to deal only with them for some period of time. They don't want to compete. They're not looking to get into a situation where there are competing offers on the table at the same time. They want to make their offer, have their discussions with the buyer or the seller, and try to get a deal done. And they want a certain amount of time to do that. Usually these exclusivity provisions are on the order of somewhere between 90 and 150 days. That's a pretty typical timeline for a healthcare transaction, depending on the state, depending on the regulatory requirements, depending on the size of the deal. Sometimes they can move faster, sometimes they take longer. And oftentimes these exclusivity provisions have a way to extend them for an additional time if it's necessary. The LOI really sets the tone for the overall deal, so it's important that it's well crafted, and if there, it addresses sort of what I see as the big issues in most deals. I do strongly encourage buyers and sellers to seek legal advice before they sign a letter of intent. Let's go to the next slide. All right, your next step is going to be due diligence. Really, really important for buyers because this is where you learn everything you need or want to know about the target entity, what you're buying. And really the concept of caveat emptor really, really applies in transactions. Buyer beware. It's your responsibility to learn about this organization. On the flip side, it's the seller's obligation to be transparent and to be truthful in responding to questions from the buyer. If there's some specific question they ask you and they say, I'll give you an example. Have you completed all of your HIPAA security risk assessments for the last 4 years? If you haven't done them, you have to say you haven't done them. Is that a great compliance response? No, but it is the truth. And buyers need to know that. That's a risk that they have to assess as part of the transaction. I say that because that's a really common one where especially smaller organizations struggle with that. And sometimes they have not been as diligent as they should have been to do all of the things they're required to do to comply with HIPAA. And but it's the seller's job to be transparent, and it's the buyer's job to ask the right questions. So both parties do engage in some due diligence to a certain extent because sellers often want to know things about buyers. They want to know what are your source of funds to pay for the transaction, which of my employees are you keeping or not, and what is the overall timeline and structure of this deal going to look like. There are so many transition things that have to happen between the time you first start talking and when you close the deal that the parties really need to have good communication with each other, and it does require a certain amount of transparency by both sides. Buyers are going to look at financial statements, tax returns, reports on liabilities, business operations, office locations, licenses, certifications, personnel matters, contracts, all the other aspects of the business to fully understand it as part of this process. Let's go to the next slide. I'm going to go ahead and turn it over to Heidi if you want to pick up on due diligence at this point and let her bring this home.
Sure. Thank you, Jennifer. And again, as she said, thank you to all for joining us on your lunch hour. So due diligence is really a very important step in the transaction. It's probably as important, if not in some instances more important than the actual documentation itself, because the due diligence is going to uncover any issues that you have out there. So one of the first things that you should do is a mini claim audit. And this is particularly important if the purchaser is purchasing Medicare, if they're keeping the provider numbers, because then Medicare and Medicaid liability is going to follow those provider numbers. So you want to do a claims audit. Now, this doesn't need to be 100 claims. You can usually pretty quickly figure out what's going on with even a half dozen or even, half dozen claims. I usually recommend at least 10 claims be looked at, just because, again, you want to get some sort of feel of what's going on. And, if there are systemic issues, they'll become apparent pretty quickly. Again, you don't want to close without having done a claims audit, because again, if there are issues that are revealed in the claims audit, these are things that you want to bake into your transaction document with limitations of liability or perhaps an escrow or a holdback that we'll discuss later. You may need to engage an expert if necessary, so don't be afraid of doing that. And again, the claims audit is going to identify any weaknesses in medical records and other documents. So again, it may not be that you have financial exposure, but in the case of an audit, you want to make sure that the documentation for anything in the past is solid, and you can again help identify which employees you might want to keep, which policies and procedures you need to change, and so on. Again, big problems may greatly reduce the purchase price. They can lead the buyer to seek a large post-closing escrow, and both Jennifer and I have seen that, where the buyer keeps an escrow, more of an escrow and for longer, or it might kill the deal entirely. So until you sign the actual purchase agreement, you still have the opportunity to back out if the transaction isn't looking good, which is why you want to do the due diligence. Next slide, please. So once you've done your due diligence, if you've retained a lawyer, as Jennifer recommended and I recommend as well, your lawyer is actually working on the purchase agreement in the background. But the purchase agreement then becomes the definitive agreement for any transaction. It is binding, which again is why you don't want to finalize it until you've gone through your due diligence. And what it does is it sets out the price, risk allocation, and all other materials or provisions of the transaction. And so it's going to serve as the basis for the legal rights of both the purchaser and the seller regarding the closing, what happens at closing, how the purchase price is paid, and any notes that you have, or promissory notes or delayed payments, penalties, and any liability exposure. So you have to really make sure you understand very clearly what is in your purchase transaction, and you want to review it very carefully with your lawyer. Again, it is very important that this document really does reflect what you want and intend to be the case regarding the purchase or the sale of the target business, because once you sign that document, now everything is written in stone, and you will be held to whatever is in that purchase agreement. Next slide, please. Okay, so we essentially have three types of transactions that are reflected with slightly different documentation in the purchase agreement. We have an asset sale, and that is where the buyer acquires certain specifically identified assets, property, and liabilities of the seller, but not the seller equity. And in this case, those assets will have a new owner after closing, and if it's substantially all of the assets, then you may end up with a new employer ID number as well. Another kind is an equity or a stock sale. This is where the buyer acquires all of the seller's equity interest. So if you're a corporation, they're buying all the stock. If it's an LLC, they're buying the membership interest. And so what happens here is the buyer acquires the entire business and all of the liabilities. And so what this looks like is the entity remains in place, so the same owner of the license and all of the assets, and the same EIN after closing. This is more of a change of interest sort of behind the scenes. And finally, you could have a merger. This is where two companies come together to form an entirely new entity, or one company merges into the other. We don't see as many of these. We usually see either an asset sale or an equity sale. Next slide, please. All right, so some unique issues that we have in these sales. So in an asset sale, what we find is that home health and hospice agents typically agencies typically do not have many what are called hard assets. Those are things like vehicles, equipment, inventory, right? Computer equipment, and so on. Most of the value is in goodwill because you are providing a service. So there's not a lot of hard assets. In an asset sale, the buyer generally does take assignment of any Medicare or Medicaid billing numbers, but few of the other liabilities. So for example, let's say the agency did purchase a vehicle. Typically the buyer would not take on the promissory note or the car loan for the vehicle. This is very common, again, where the seller has non-healthcare debts, like a car loan. The buyer doesn't want the Medicare or Medicaid numbers, or the buyer is particularly risk averse. And here you can sort of pick and choose what the buyer is taking and what remains with the seller. In a stock or membership interest sale, again, the legal entity remains in place and only the shareholders or members behind the scenes do. And in this case, the buyer takes assignment of not just the provider numbers, but takes on all other contract and company liabilities. So if there is a tax issue because they haven't paid their taxes, if they are facing overpayments because there is an audit outstanding, all of that flows with the company and the buyer remains liable for that. Well, the entity remains liable for it, and the buyer then, of course, stays liable for it. In a merger, successor liability is going to depend on the structure of the transaction. And again, there's some things that go into that. We're not going to go into that in a whole lot of detail. Next slide. Purchase price. This is very, very important, and this is where a lot of the negotiation usually happens, and where it can be often affected by the results of the due diligence. Buyers typically want to pay only a portion of the purchase price at closing, and they may want to hold something back for potential liabilities. Sellers, of course, want 100% at the time of closing. We have seen holdbacks that range from 5 to 25 or more % of the total purchase price, again, sort of depending on what the risks are that become apparent during the due diligence process. And often these are put in an escrow account. Escrow periods can range from 6 to 36 months, depending on the risks. Again, it is really going to be specific to the particular transaction and the specific issues that may become apparent during the due diligence process. You do want to have a formal escrow account agreement to protect the seller and to ensure that the seller gets any payment of the holdback. The last thing you want to have is have the buyer hold the escrow, and then for whatever reason the buyer doesn't pay this. Costs a little bit of money, but most banks will do escrow accounts, and so it is well worth whatever fees you pay to have a formal escrow account and agreement. And again, the escrow account and agreement is what it's going to say. It's going to establish certain conditions under which the holder of the escrow, the bank, releases the funds to the seller, and so it really provides protection for everybody. And again, escrow accounts may or may not be interest bearing. Typically, for shorter times, they're not. So again, you just have to work through these with the parties and then figure out what you want to do. Some sellers are willing to what is called essentially owner finance, and what they will allow the buyer to do is pay either a down payment and then structured payment over time. And this is subject to a secured promissory note. Just like when you purchase a vehicle, you can enter into essentially what is a loan and pay it off over time. And the loan is secured by the assets of the agency. Sometimes you have to do things like personal guarantees, but there's a whole variety of ways to structure this. Purchase price adjustments at closing are very, very common. One of the most common ones is, again, if there's any debts, that the purchase price will go to pay any debts of the seller or the agency that are outstanding. You can pay the transaction costs of the seller. You can keep a certain amount of working capital. I'm sure Jennifer has a whole list of things that she's seen. I've seen things like there is an evaluation of how many patients you have at the time of closing, and if the patients, aren't at a certain level, then there's adjustment again. Again, you want to be very careful. You're not violating the anti-kickback statute, but there's a whole kind of litany of things. Particularly if there has been a longer period between the time of signing the purchase agreement and closing, and the seller has been running the business in the meantime, that's very much the case where we tend to see purchase price adjustments. So don't be surprised if you see something like that. It's very common and something that should be expected. Next slide, please. Representations and warranties. As we lawyers say, these reps and warranties are essentially promises or statements that certain conditions are true, and these are legally binding promises. And your disclosure schedules will often identify specific exceptions or facts tied to reps and warranties. So for example, a rep and warranty might be that all licenses are valid and in good standing, or that there are no debts outstanding other than the sort of normal operating debts and so on, accounts payable. A material inaccuracy in the reps and warranties can be grounds for the purchaser to sue or seek indemnification. So again, you want to make sure that your reps and warranties are very common. So again, common examples are a statement that the financial statements and reports are accurate and complete, that there is no litigation or audits pending, and that the business has complied with applicable laws. And we put these in virtually all of, I shouldn't say virtually, we put these in all of our purchase agreements. Next slide, please. We do have some unique reps and warranties in a healthcare transaction. As I said, a very common one, and again, one that Jennifer and I put in all of our transaction documents, is that the seller has all licenses, certifications, and contracts necessary to operate, and that those licenses and certifications and contracts are current and in good standing. Another one, especially if you're looking to take on Medicare or Medicaid patients, is that the seller is enrolled in Medicare or Medicaid, and those enrollments are active and again in good standing. The seller and its owners are not subject to any disciplinary or corrective actions or appeals. An important one is that the seller has been conducting exclusion screening, has records of it, and that no employees, contractors, vendors, or owners are excluded. The reason you want this is because if they haven't been doing that, then again, the purchasers may be liable on down the road for fines and penalties, and refunding of claims and reimbursements that were paid that are attached to or the result of an excluded individual's work. So another one is that there are no claims, enforcement, or other actions, administrative proceedings, audits, or investigation pending. Again, you want to make sure that you have this. I have a story where one of my clients had, I think it was United, may have been Cigna, but anyway, they had an audit by a private healthcare payer, and this was during the pandemic, and the audit was actually prior to the pandemic, but everything kind of stopped during the pandemic, right? And they hadn't heard And since they hadn't heard, they assumed that they had passed the audit. They went ahead and completed they completed a transaction to sell their agency. And 6 weeks after they went to closing, the private insurer sent back the results of the audit and said, "You now owe us fill in the amount of money. As a result of the audit, we found these deficiencies in the records." Well, there was a scramble. There was, a question as to whether or not they had violated the rep and warranty about no audits pending. And so we eventually resolved it, but there was definitely a little bit of a high blood pressure and scrambling to resolve that issue. In home health and hospice deals, again, because we do have the 36-month rule, the seller has to make a rep and warranty addressing the 36-month rule. And if you have had a change in majority ownership in the last 36 months, there are ways to address it, but you want to make sure that you don't violate that. And so therefore we have a rep and warranty for that. Next slide, please. Indemnification. Indemnification is a fancy way of saying who has to pay or who is financially responsible when certain bad things happen. There is indemnification to protect the buyer. The seller agrees to compensate and hold harmless the buyer for any problems that arise in the business as a result of the seller's actions prior to closing, breaches of reps and warranties, or claims by third parties that relate to the pre-sale period. Indemnification provisions for a seller usually, that protect the seller are usually that, again, the buyer is in good standing. They're not about to, go into bankruptcy, and that they'll be able to pay the note. And those are the kinds of indemnifications, generally speaking, that we look at for a seller. Again, you may want to consider escrowing a portion of the purchase price, tongue-tied today, to cover indemnification for a defined period. It's also, again, if this happens, then this is who pays, or if you have insurance to address for some of that. So you want to make sure that the indemnification provisions are clearly thought out and also clearly spelled out. You don't want to be in a situation where you're like, oh, well, we talked about if such and such happens, then this happens, but it's never reduced to writing as part of the purchase price. So you want to make sure you have that in place. Next slide, please. Qualifications and exceptions. Qualifications and exceptions are anything that limits a party's liability. So you can actually have a minimum amount of indemnification or put a cap on it, or a disclaimer or revision of certain reps and warranties. I had in a recent transaction an indemnification provision that said the seller is going to be indemnifying the purchaser, for anything, resulting from a claims audit. However, the indemnification provision didn't kick in until there were at least, I think it was $10,000 in claims, and this was a larger transaction. So the purchaser was willing to accept a certain amount of liability from outstanding audits. They were aware of those. They knew those were coming. But anything beyond sort of a defined amount, that was when they were going to return to the sellers and get liability. You may also have a materiality qualification. So again, that anything that is considered material to the running of the business becomes something that you indemnify the other party for. There are things that may not be true, but that are immaterial to the transaction. You may have time limits on the indemnification, and again, here you want to consider statutes of limitation in relation to healthcare laws. And again, your qualifications and exceptions are very, very negotiable, since they are very fact specific, and again, are going to reflect the results of not just the two parties' posture, but the results of any due diligence. Next slide, please. Closing. Sometimes closing occurs on the same day the purchase agreement is signed, or usually what it does is it occurs later, especially if there are third-party consents that are involved or if there is financing that needs to be involved. For example, here in Texas, we have to notify our HHSC, Health and Human Services Department, at least 30 days in advance to an ownership change for licensure purposes. That's in our law. So in those circumstances, we sign the purchase agreement and then closing occurs sometime after. Sometimes the parties go ahead and notify HHSC, but then HHSC usually wants to see a signed purchase agreement, so you're kind of stuck. Again, there may be other reasons that you go to closing later, particularly if you have to get loans or something like that. If this is your situation, then your conditions to closing is a key section of the purchase agreement, and failure to meet a material condition is a reason not to close. So examples here are that the buyer can't qualify for a license, key consents cannot be obtained or acquired, or financing falls through. Next slide, please. So once you get to closing, the parties actually review all the relevant documents and they agree to any last-minute revisions, if there are adjustments to the purchase price or so on. They sign the documents, and at that point, the ownership of the assets or equity interests officially transfers. And once the documents are signed, then the purchase funds are transferred, or escrow funds are deposited with an agent. And again, you can, depending on the size of the transaction, do this with a check. I would recommend a cashier's check or a certified check, or more commonly, what we see are wire transfers, where the bank is instructed to transfer money from the purchaser's account to the seller's account. And again, you want to have all of that taken care of and notified and written down beforehand. Next slide, please. Closing actually can be fairly straightforward and almost an anticlimax. After closing, the relationship between the parties rarely ends after closing. Many buyers want a transition period where the seller sticks around for some period, and they do this to assist in retaining employees and or patients, and also to help the purchaser learn the systems and the policies and the procedures and the way of doing business that the seller has had. The goal of the seller here is to minimize its exposure to liability from claims made by the buyer. And conversely, the buyer now is running the business with all of its attendant advantages and disadvantages. And so here, during this transition period, in particular, if issues arise that the seller should have disclosed or for which the seller is responsible, as the buyer starts looking through the books and records, the buyer may seek a legal claim. And again, be aware that the buyer's ability to seek a remedy is not limited to the initial transition period right after closing. That can come up later. Again, some transactions have deferred payments of various different types, like an earn-out or a promissory note. And the buyer and the seller are going to be relying on each other to comply with any of those deferred payment obligations and reporting of that information. Next slide, please. Many deals also include restrictive covenants. Some protect the buyer, such as a non-competition and non-solicitation covenant, and some may concern the seller or its reputation, and these may be covenants concerning which of the business's employees the buyer takes on, and information in relating to how those are handled, terminations, pay, or severance. There's a whole variety of things. I will say that many of these restrictive covenants are a common subject of disputes between the parties post-closing. And again, you want to have these reviewed by an attorney. Non-competition agreements, for example, right now are a hot topic and a rapidly evolving area of law. Under most states' laws, they are to be limited in their scope by geography, time, and practice area. The Federal Trade Commission put out some rules relating to non-competition agreements for individuals and employees, and you might want to have that again for key employees from the seller, like managers and so on, or the former owners. And so some of that is the subject of legal dispute right now. There is a case going on in Texas that is actually applicable only to the parties. There is another case in, I think it's Philadelphia, in the Pennsylvania area, where the judge actually upheld the non-compete agreement. But again, these are definitely a hot topic right now. So if you're going to be doing any restrictive covenants, again, you really have to have them reviewed by an attorney because this is rapidly changing. Next slide, please. Again, as we said earlier, home health and hospice deals may include post-closing purchase price adjustments based on updated valuations of the business or what the status is of the accounts receivable that exists on closing date. And you really have to make sure in your purchase agreement you define how post-closing accounts receivable will be split. This is a really big source of friction. Jennifer and I both see this. If you don't spell this out properly and figure out how to handle this in advance. And even when you do, there is often friction about it. So buyers are going to want purchase price. Go ahead, Jennifer.
No, I would say more importantly, your clients have to understand what's written down, because
right.
I will say this is one of the thorniest and most confusing parts of any transactional document, whether it's a straight up, seller's going to retain accounts receivable, and everybody in the industry knows those can take days, months to come in. You've got to have a process for how do you account and reconcile those. Alternatively, if you're set up with a working capital arrangement where the seller's going to provide a certain amount of working capital, which is mostly going to be accounts receivable, again, you have to have some kind of reconciliation process later on, and that has to be transparent, and there has to be, information flowing back and forth. So this is a huge source of misunderstanding between parties sometimes. So I always like to make sure everybody's on the same page. They understand what the process is going to be.
Yes, huge source. I had a recent transaction where we had both a working capital requirement being left in the business and a provision for how accounts receivable were going to be split post-closing. And this was one of the circumstances where the buyer stuck around again for a certain amount of time. And boy, the day after closing, even though the purchasers had been on the premises and had been doing all this due diligence and thought they understood the accounting principles, boy, the day after closing, there was already a dispute. So I agree with Jennifer, huge issue. Take the time to figure this out and make sure everybody understands it and it is properly reflected in the wording of the purchase agreement. So buyers will often want purchase price adjustments to discourage the buyers from letting the business fall apart during the transaction negotiations or while waiting for closing. Again, in some states you have to notify in advance. There may be reasons why you can't go to closing. You may need some other consents and so on. So the buyers don't want the seller to just say, okay, I've signed everything and now I can just sit back and put my feet up. No, this is still an operating business. You don't want employees to leave. You don't want patients to be, transitioning out. So that's why there is often a provision for that. And a final thing for after the closing to remember is that you have to file your Medicare change of information or change of ownership applications quickly. You only have 30 days after closing to do this. So make sure you do this and don't forget that. Next slide, please. Specific issues for home health and hospice, we've already mentioned 36-month rule. Again, this limits direct changes in majority ownership to no more often than every 36 months. If you have had a change in ownership within the last 3 years, there are ways to address this. Often what we see is there is a management agreement where the purchaser steps in and starts operating the agency until the 36 months is up. We don't see this if there's been a change of ownership in the last year, but if it's been a few months, if you only have a few months left on the 36-month rule, that's often where we see some sort of interim management agreement. As Jennifer said, hospices with an asset sale or 100% sale of equity are now subject to enhanced oversight by CMS, and this may include prepayment reviews for anywhere from 30 days to a year.
Yeah, just to clarify, that's not applicable in Louisiana, though. So good luck for good for Louisiana.
Yes, there we go. Also, again, aside from the 36-month rule, you may want to have management occur. So there may be some interim management agreement. There may be a reason that the buyer wants to step out. Perhaps they're more than ready to retire. Perhaps there are health issues or family issues where the buyer really just wants to step out very quickly and not wait for closing. I also had a circumstance where, and this was rather unique, but it took us 1.5 years to get to closing. Most of the time it is not like that. Don't everybody get scared. But this particular circumstance was so strange. And so in that interim period, we actually had a management agreement for that particular transaction. You want to make sure you look at the seller's payer contract and look in particular at the assignment and notice provisions carefully. In some circumstances, the payer contract may actually require that the insurer consents to a sale in order for that contract to remain valid after closing. In other words, the payer has entered into a contract with specific parties, and they want to make sure that those specific parties stay in the picture. And if those parties change, then you have to get a new contract. So this is also something that crops up fairly frequently. You need to figure out what staff you're going to retain. Again, staff are very crucial to retaining patients. The patients really don't know ABC Home Health from LMNO Home Health. All they know is that my nurse, Betty Jones, is with ABC Home Health, and I really like Betty Jones. And so if Betty Jones goes to another agency, then I'm going to follow Betty Jones. So you want to make sure you're able to retain your staff because they are key to retaining patients. If you are accredited, don't forget that you have to notify your accrediting body. Other things that you should actually be doing, and you've actually done this prior to closing as part of the due diligence, but you can do it as well afterwards. You want to review the compliance plan, policies and procedures, and any audits and figure out what needs to be changed in the compliance plan and policies and procedures. And you want to also figure out how you're going to handle any audits. Again, if there is any question of audits, those would have come up during the due diligence. And if you have a fear of that, monies would have been escrowed to address any audit issues. And finally, consider cost-saving strategies that can be realized in the transaction. You can maybe remove redundancies, streamline technical or administrative systems, or increase your outreach or marketing efforts. And again, part of making sure as a purchaser is this a good deal for you? Again, you should have done most of this work as part of your due diligence ahead of time before you've even gotten to this point. Next slide, please. All right, I know we're a few minutes over, but we're wrapping up. So these transactions are complex and can be lengthy, but if you do your due diligence and your research, they can be very, very rewarding. Whether buying or selling, you always want to make sure that the target business is continuing to operate in its customary manner while negotiations are pending, and often you will put that in the letter of intent. You want to be aware of fraud and abuse issues, such as Stark and the anti-kickback statute, as Jennifer mentioned earlier. You do want to engage experienced professionals to handle their transaction, valuation, and negotiations. And this is going to be lawyers, appraisers, and accountants. And again, this is not advertisement for us particularly as lawyers, but I have been on transactions where the lawyer on the other side literally was my sister-in-law's cousin's brother's nephew, and he has a general practice. He does traffic tickets and wills and estates and just general business law. Let me just tell you that that transaction took a little bit longer to negotiate, again, as Jennifer said earlier, because the lawyer wasn't familiar with some of the weird situations and requirements that we have in healthcare law. And again, beware of the long-term risk allocation issues that go on long after closing. You should have written those into your purchase agreement, but you need to keep a mind on those post-closing as well. Next slide, please. All right, so that's our presentation. Gio, if there are any questions?
No, there's no questions as I can see from on my end. So I think we'll just close out. So thank you so much to our presenters, Heidi and Jennifer, for that information. And thank you to our attendees for joining us today. Like I said before, I'll be sending out a copy of the PowerPoint slides tomorrow. But if you have any further questions, please reach out to Jennifer or Heidi, as you can see above their email address. Other than that, have a great Tuesday. Thank you, guys.
Thank you all.